Hello, everyone, and welcome back to our juvenile justice class. This week we're talking about Chapter 1 and 2 within your juvenile delinquency book, as well as some of the cases that you've been assigned. So right now we're talking about Introduction to Chapter 1, and within this chapter we're going to talk about the definition of a juvenile is defined for jurisdictional purposes in most states as a person who is younger than age 18. All this does vary in some exceptions. The juvenile justice system handles legal matters involving a juvenile. It is a separate legal system that was set up for juveniles under the belief that children are different than adults and therefore should be treated differently. The juvenile justice system includes police, probation, and corrections, as well as some of the other systems, the ancillary systems, like child welfare, schools, and behavioral health systems. Although those aren't really considered to be part of the juvenile justice system, these ancillary systems, they have a significant impact on the juvenile justice process and the outcomes of those involved. The juvenile courts were established based on the doctrine parens patriae. As such, it acts as in place of the parent or in place of the guardian in loco parentes for the best interest of children who are in need of help or guidance. A judge's juvenile to be delinquent when a jurist or a judge or a magistrate determines that a juvenile has committed a delinquent act. He or she does not find the juvenile guilty of a crime because the word guilt really implies criminal intent. Rather, the judge or the magistrate adjudges the juvenile to be delinquent. In other words, finding the juvenile has committed a delinquent act. Once they are adjudicated as delinquent, the jurist does not impose the juvenile a sentence because a sentence implies punishment for a crime, which we find in adult court, in criminal court. Rather, he or she renders his disposition. And the disposition is a juvenile has not been found guilty of a crime, but is being disposed. The juvenile justice framework, the rehabilitative framework in juvenile justice has shifted a number of times over the past few generations. A rehabilitative philosophy today no longer extends to all matters related to delinquency, and many states have increasingly passed more punitive laws that focus on punishing juvenile offenders rather than rehabilitating them. The original intent of the juvenile court was to be rehabilitative, and as we'll see in the history, to take them away from the horrendous conditions that they were experiencing in the adult criminal system, the adult jails. There are collateral consequences, the enhancement to adult sentences, registered sex offender, and hurdles in obtaining an education or a job. The civil courts handle most matters that do not involve the criminal acts, and criminal courts handle personal and property crimes. As I said, the juvenile court, the purpose of the juvenile court that began in 1899, the state juvenile code purpose statements fall into 5 distinct groups: the balanced and restorative justice, the BARJ, philosophy that provides for a balance between public safety, individual accountability to the victim and community, and the development of skills to help the offenders become law-abiding and productive citizens. We have the Standard Juvenile Court Act that was issued in 1925. It was revised in 1959. Provides that each child coming within the jurisdiction of the court shall receive the care, guidance, and control that will conduce to his welfare and the best interests of the state, and that when he is removed from the control of his parents, because now the juvenile justice system is the parent, the parens patriae, the court shall secure for him as nearly as possible equivalent to that which they should have given, that should have been given him by those parents. The Office of the Juvenile Justice and Delinquency Act in 2013 imposed the Standard Juvenile Court Act. The guide also included in that is the Guide for Drafting of Family and Juvenile Court Acts Guide, and this is that is concerned with the care and protection of children's mental and physical development, incorporates supervision and rehabilitation, removes a child from their home only when necessary to the child or public safety, and guaranteeing their constitutional rights. The guide for the drafting of the Family and Juvenile Court is really concerned with their mental and behavioral well-being. The child welfare focus, which is the best interest of the juvenile as the sole or primary purpose of the juvenile justice system. Also, the tough on crime. Adolescents are not young adults, so the tough on crime resembles the purpose of the adult criminal court in that they emphasize offender accountability and punishment, deterrence, and community protection. There's a small number of delinquent cases, however, that may be certified by the Attorney General for the prosecution in the U.S. District Courts. Remember that their adolescents are different than young adults. There's differences in the adult and the adolescent brains that we're going to talk about in this class, and children are developmentally immature compared to adults. And something that you'll hear me talk about a lot, and I talk about this in my research, prefrontal cortex in the brain does not stop developing until the early to mid-20s, and this is especially true for males. So when we look at the prosecution of a juvenile or waiving them to an adult court, we have to remember that even though they may commit an adult act, they're not acting in the same brain function as an adult. The juvenile court jurisdiction covers delinquency and status offenses. The delinquency is an act committed by a juvenile that would be considered a crime if committed by an adult. Now, status offense is not the same thing. It is a violation only when it is committed by a person under the age of 18 because of his or her status as a juvenile. It's because they are a juvenile and they are therefore not deemed an adult under the age of 18. The Juvenile Justice and Delinquency Prevention Act mandates that the state not incarcerate juveniles who are involved in status offenses or abuse and neglect cases. The act is overseen by the Office of Juvenile Justice and Delinquency Prevention, the OJJDP, which is part of the U.S. Department of Justice, the DOJ, and the federal courts and jurisdiction. The Delinquency Prevention Act in 1974 that I just mentioned earlier was revised again in 2002. It's the first comprehensive federal law for the prevention of delinquency. The Federal Juvenile Delinquency Act defines delinquency as the violation of a law of the United States committed by a person prior to his 18th birthday, which would have been a crime if committed by an adult. The OJJDP Act core requirements: the deinstitutionalization of status offenders and non-offenders. This requirement mandates that the liberty of youthful offenders not be taken away through detention or placement in a secured facility if they did not commit a crime, unless it is for a violation of a court order. Another of the requirements of the OJJDP Act is the sight and sound separation. This requirement mandates juvenile offenders be separated from adult offenders when they are being detained, such that detained juveniles should not be able to see, hear, or have any interactions with adult criminals. It also includes jail and lockup removal. This requirement mandates that juveniles not be detained in adult jails. There are exceptions to this that can be allowed as long as the sight and sound separation requirement can be met, such as in rural areas where there may be only one jail. For instance, I was working with a juvenile many years ago, and he ran away from the treatment facility he was at in Limestone, Tennessee, and he was picked up by the police. Well, they detained him, so they put him in a detention cell in Greenville City Jail, but he was out of the sight and sound of any adult offenders. Also included in those requirements is the disproportionate minority confinement. This mandates, in effect, to reduce the disproportionately higher minority youth involvement related to their proportion in the population at every stage of the juvenile justice system. The juvenile court jurisdiction. What is the age of jurisdiction? And this varies by state to state, and I believe there were some that discussed this with in the discussion question, that it should be the same in every state. And as we'll see, and as you have seen, that even though there's many times that a juvenile can be waived to adult court, it can always be changed. It doesn't. There are some states that have an automatic mandated age, but there's other states that can, a 12-year-old, even though the automatic age may be 14, if he commits a certain crime, he can be waived to adult court. So state laws vary concerning who falls under this jurisdiction of the juvenile court, and as I said, the minimum ages at which juvenile offenders can be transferred to the adult court vary. Most states do not specify the lower age for juvenile court jurisdiction for delinquency cases. And imagine, why do they do that? They do that because if they actually specify the lowest age, and that means what's going to happen. There's going to be someone under that age that commits a violent crime. As I just mentioned, one of the jurisdictions that falls under juvenile court is the waiver to adult court. We're going to talk about this a lot more in depth later in the class. This occurs when the jurisdiction of a case involving a juvenile offender is transferred from the juvenile justice system to the criminal justice system or the adult system. There are different types of waivers. There is a legislative waiver, which is for a serious violent offense such as a capital crime or murder, where the juvenile is automatically in the jurisdiction of the criminal justice system by statutory law, and results in the automatic waiver or transfer of that youth to the adult court. Serious violence offenses such as capital crimes or murder is automatically in the jurisdiction of the criminal justice system. Concurrent jurisdiction. This is when there are certain offenses that are in the jurisdiction of both the juvenile justice system and the criminal justice system. As I said, we're going to talk about this in more detail. We also have the prosecutorial waiver, where prosecutors have the discretion to decide whether or not to transfer such cases to the criminal court system. And also under this, under the waivers to adult court, which is really important to remember, that once an adult, always an adult, meaning that once a juvenile is waived to adult court, if they commit any future crimes, they will be automatically ruled under by the criminal court. The Federal Juvenile Delinquency Act defines delinquency as a violation of a law of the United States committed by a person prior to his 18th birthday, which would have been a crime if committed by an adult. The U.S. District Courts, some juveniles who are apprehended by federal law enforcement agencies may be prosecuted in federal courts. A small number of delinquency cases, as I mentioned earlier, may be certified by the Attorney General for the prosecution in U.S. District Courts, especially those involving a serious offense, such as a violent felony, an offense involving a firearm, drug trafficking, and even cases that are of interest to federal agencies. This is the flow chart of the juvenile justice system, and I'm not going to go through this. You can look through this, and I recommend you do this strongly. Also, within this PowerPoint, I will upload my note pages for the lecture, but if you look down when you're reviewing your PowerPoint, I have many of my notes already down in the PowerPoint notes section of each slide. Okay, now we're going to talk about the process of the juvenile justice system. As we know, if you've had any policing classes, we already know that law enforcement, they're the gatekeepers. They're usually the first ones that see every type of potential offender, both juvenile and adult. So only a small number of juveniles actually end up being processed through the juvenile justice system. Law enforcement involved with non-criminal matters, their involvement such as missing children, curfew violation, runaways, truancy, neglect, and abuse. Most local police departments, 90%, have special units dedicated to cases involving juveniles, family issues, and many, as we've talked about, and I know officers at the schools, our resource officers that are known as the school resource officers. Those are sworn officers that are employed by the schools. More than 2/3 of cases in which juvenile justice system is the original jurisdiction, they were actually referred to juvenile court, while the remaining cases were either referred to criminal court or handled within law enforcement agencies. And we're going to talk about that, about many of those cases that are handled prior to even going to court. Temporary detention is when law enforcement agency personnel are required by federal regulations to detain a juvenile in a secure environment for no more than 6 hours. Juvenile Justice and Delinquency Prevention Act mandates the separation of juvenile offenders from adult offenders when they are being detained, which we just talked about. The Miranda warning, we'll talk about this more when you look at your cases. Even juveniles must be advised of their rights. So the Miranda warning to inform the individual in custody of the right to remain silent and protecting against self-incrimination and the right to an attorney. This began to change in the 60s with a series of the U.S. Supreme Court rulings that are mentioned in your book as well as in the cases book. That afforded the same due process rights to juvenile offenders as adult offenders. And popularly used Miranda warnings require a 10th grade level of comprehension, which research indicates many juveniles lack, as we've just talked about. The International Association of Chiefs of Police, in conjunction with the OJJDP, recommends a simplified version of the Miranda warning that requires a comprehension level of a 3rd grader. As I just mentioned, the Supreme Court decisions on Miranda and some other related rights is JDB versus North Carolina in 2011. The suspect's age should be taken into account. Interrogation and the confession of juvenile suspects. Court ruling changed over time. The currently suspect's youthful age must be taken into account. Most law enforcement officers are not trained to interrogate youthful offenders. Not only do we have the JDB versus North Carolina, we also have North Carolina versus COM in 2013. Diversion is a process that we see frequently used in the juvenile justice system, and this occurs when a case is handled informally outside of the juvenile courts. It can occur at any stage of the juvenile justice system, from apprehension to post-adjudication. Diversion to an alternative program and service could minimize the negative consequences on a juvenile, and diversion is less costly and reduces the burden on the juvenile courts. Now, also, there's formal diversion, which is where the juvenile must agree to specific conditions for a specified time period that are really spelled out in a written agreement. It's called a consent decree. The examples of diversion include restitution, fines, community service, school attendance, drug school program attendance, probation supervision, and other areas. The prosecutor's office is also one of the processes that a juvenile might go through within the juvenile justice system. Only half of all cases referred to juvenile court result in a formal intervention by juvenile court, while the other half are handled informally. That's an important statement to know. Once a juvenile is referred to juvenile court, they go through an intake screening after reviewing the case, including the age of the offender, the seriousness of the offense, the prior juvenile court record, school record, family information, an intake officer assigned to the case decides to request a formal intervention by juvenile court, and then you proceed to informally handling the case or dismiss the case altogether. Only half for some serious offenses, the intake officer has no choice but to request a formal intervention by the juvenile court, which is dictated by law. Now, once the intake officer decides to formally process a case in juvenile court, one of two petitions must be filed: the delinquency petition, which explains the allegations of the offense, or the waiver petition, which requests transferring the case to criminal court. Here again is a great chart that shows the process of the juvenile justice system. I really do recommend that you look over this. Many juveniles that have contact with anyone in the juvenile justice system, law enforcement, many are immediately released to their parents. Some are held in the facilities, and juveniles may be placed in a secure detention facility really at any stage within the system. We have the shelter care, hearing, and pre-trial detention. Some juveniles are held in the secure juvenile detention facility pending a hearing before the judge, and this is based on the seriousness of their offense. So the decision for detention, as I said, is based on their seriousness, their risk for flight, safety of the juvenile, safety of the community. But what's interesting to take under advisement is they do not have the right to bail. Detention hearings in front of a judge must be held within a few days. Plea bargaining is another process with contact with the juvenile justice system, and it occurs when an offender admits to committing an offense in exchange for a lesser charge and a possibility of a lesser sentence or a disposition. 95% of all convictions actually end with a plea bargain, and you're most likely to occur at the adjudication hearing. Likely results in a lesser disposition for the offender. Juveniles are usually warned against pleading guilty because of the extralegal collateral consequences, and many times those that are working with juveniles in the juvenile justice system do not recommend this to the non-benefit of the juvenile. Higher risk among juveniles and adults for falsely pleading guilty to a crime they did not commit. Also, a juvenile can go to trial. The adjudicatory hearing is the facts of the case are presented in front of a judge who determines if the juvenile is actually responsible for the offense. Once they are adjudicated, probation officer prepares a disposition plan based on his or her assessment of the juvenile support systems and available programs. And only in some states do juveniles actually have a right to a jury trial. Competency comes into question. Legal competency requires that a defendant, even a juvenile, understand the charges brought against him or her and the seriousness and possible penalties of that charge. Today, a majority of states do have separate guidelines for the use of competency in juvenile courts and do not as often have to apply the criminal court guidelines. The legal competency can actually be recommended at any stage within the process. Decision making in juvenile court, there are major differences between the juvenile and an adult court. Juvenile court traditionally focuses on an individual offender to determine individualized intervention that focuses on rehabilitation and treatment. The adult court, in contrast, focuses on the seriousness of the offense committed. The juvenile justice system expected to take into account both extra-legal and legal factors in deciding what is best for the juvenile. The extra-legal factors can include family information, school records, any support system, history of drug and alcohol abuse, and even their work record. Now, through disposition, there are a multitude of disposition options that are available. Some of those include a warning, restitution to the victim, community service, counseling, confinement in a secure residential facility, and after release from a residential facility, the juvenile is often ordered to be under the supervision of the court or the corrections department. Less than 1/3 of adjudicated youthful offenders are actually placed in residential facilities. The confidentiality, and we all know what confidentiality is protecting the privacy of someone. And within the juvenile justice system, we have to ensure that the privacy of the juvenile is protected. And there's a shift in the view on confidentiality in juvenile court. Many states prohibited the public from attending juvenile court proceedings to protect the privacy of the youthful offenders. In 1977, U.S. court ruled in the Oklahoma Publishing Company versus the district court ruled for Oklahoma City, prohibiting publication of legally obtained name or photo of youthful offenders because of infringement on the freedom of the press. By the 1980s, most states had removed confidentiality provisions, with only 13 states in 2011 having statutes making these hearings closed to the public. In 2009, all states except for Rhode Island had procedures in place for the sealing and or expungement of juvenile court records. The child welfare system, as I mentioned earlier, is an ancillary system. Federal policy, the Child Abuse and Prevention and Treatment Act, the CAPTA Act of 1974, child maltreatment defined as a serious harm to children caused by parents or primary caregivers, including babysitters and extended family members. Harm includes any type of abuse such as physical, sexual, emotional, as well as neglect. The federal government plays an important role in providing support through the Children's Bureau, U.S. Department of Health and Human Services. State policy, the child protective systems that many of you may be involved with, may have worked for, vary from state to state and include both public and private services. The child welfare system focuses on ensuring the safety of children. Child Abuse and Prevention Act of 74 defines maltreatment as serious harm to a child caused by parents or their primary caregivers that can include babysitters, extended family. Stages of child maltreatment case processing, abuse including physical, sexual, emotional, and neglect. Most families become involved with this system because of a report of a suspected child maltreatment. And Child Protective Services, which is CPS, receive reports of suspected abuse and neglect and screen them for further investigation of child protective systems. CPS receives a report from suspected abuse, determines if there's enough information that warrants the investigation, and if so, a caseworker can be dispatched to speak with the child, the parent, others, the reporting agency, the reporting person. If they do deem that they're in immediate danger, many times they will remove them immediately. If an emergency hearing is required, the services that are required or will be in need could be investigation, substantiated, founded, or unsubstantiated. The placement of the child could be determined, and the permanency hearing, which means it determines the permanency of the child and where they will end up. This happens with any agency that works with juveniles. I've worked with an agency in Tennessee for 8-9 years, and went to many permanency plannings, permanency hearings, and this is what the ultimate goal is whenever a child has any contact with the juvenile justice system, is to find them permanency. Now we're going to move on to Chapter 2 and talk more about the history of the juvenile justice system. In the early days, most juvenile justice efforts were punitive, as evidenced by the use of dangerous and ineffective warehouse types of institutions, almshouses, houses of refuge, and other similar alternatives. We shifted from punitive to rehabilitative during the late 18th and early 19th centuries, and that was the purpose of the original juvenile justice system. The first shift away from punishment. I apologize for that. Something just popped up on my screen. These efforts at formalizing a juvenile court system ended up in expanding the juvenile justice system and actually imprisoning more children and adolescents for non-criminal activities. Since the 1950s, due process rights were established for the youthful offenders. 1980s and 1990s, we see the tough on crime approach to juvenile justice and the creation of the school to prison pipeline. That also was the increase in juvenile waivers and incarcerations. Schools implemented similar zero tolerance policies and school exclusion policies, forming what many have called the school to prison pipeline. We're going to talk about throughout here the cycles of rehabilitation and punishment. We'll talk about each of these times. So when we begin talking about 1750 to 1850, where we moved from the almshouses to the houses of refuge. The almshouses were locked one-room buildings that housed many types of people with many different problems. In loco parentis, which means to remove the children and place them with other families. Children were bound out and essentially were indentured servants for the new family as forms of social control of troubled children. This was a form of severe social control. Houses of refuge. These were new facilities that were established in major cities to help control the troubled, wayward, or orphan children. They housed a very large number of young people, as many as 1,000, including those who were delinquent, orphan, neglected, and or dependent. So they're just throwing all of them into one area. And as you'll read, they were horrendous conditions. When you should see some of the pictures of the houses of refuge, it was just deplorable. The 1800s movement to discontinue the use of adult jails or almhouses for these children and establish separate facilities. That's where we have the parens patriae, parent of the country, was established through numerous legal decisions that supported the belief that the state should act as benevolent legal parent. The juvenile court, as you see, as we talk about, gives us that separate criminal code. These next two slides, we're going to talk about the 1850s to 1890s, which is called the child saving movement. It focused on urban poor, trying to keep children sheltered, fed, and when possible, and when they were even old enough, employed. We have the Children's Aid Society in 1853, where they did this placing out system for impoverished and troubled children. And this is when over 50,000 were rounded up from mostly the urban East Coast cities. They were put on trains and then sent to the western states. This program, often did not even find placements for many of the children. That's why it's called placing out, taking children from eastern states to Midwest farms. These efforts actually tried to improve conditions for wayward children, but all the legal matters for children continued to be handled by the adult civil courts. The civil courts had no training to handle children's issues, which is why they achieved the hazardous outcomes, trying to decrease delinquency that actually increased delinquency. The reform schools were designed as small, rural, cottage-like homes that were run by parental figures who worked to educate and care for the children and adolescents. Reform schools were designed, they were focused on the urban poor, trying to keep them sheltered, fed, and, as I said earlier, employed. These were established in Massachusetts in 1886. Most facilities were operated by state or local government. They rarely included those that were convicted of serious crimes, and they did not have proactive efforts to really change the behavior. These facilities were exploited under indentured or contract labor systems. There was little improvement over the earlier attempts to manage or rehabilitate the juvenile population. This was primarily used by white children, minority children that were still placed in adults' prisons and jails. 1899 to 1920, this was the establishment of the juvenile court. In 1899 was the establishment of Cook County Juvenile Court. In Chicago. It was an institution that I've said it led to the loco parentis in place of the parents. That's important to know and to recognize. The guiding principles of the juvenile courts included optimism, that the young person could be reformed. It was a focus on how to best accomplish this, and a separation and distinction from the adult court system, which did not keep hearings and information confidential. And as we talked about, that's one of the requirements within a juvenile court system. Court proceedings were held in private and did not include jury trials, indictments, or other adult system formalities. And the court was treating these cases as civil and not criminal. For the first time, state laws began to define delinquency. And the expansion of the movement included philanthropists, middle-class citizens, and professionals. There were advancements seen across the social services, schools, a recognition of adolescence as a distinct life stage, child labor laws, mandatory school attendance, a pedagogical tracking of poverty and delinquency. The guiding principles of the juvenile courts included optimism that the young person could be reformed. It was a focus on how to best accomplish this, and it was a separation and distinction from the adult court system, which we know did not keep hearings and information confidential. Juvenile courts were handled mostly as a civil case. They viewed children as needing rehabilitation and supervision, treating delinquency as a social problem instead of a crime. The court viewed the child in need of rehabilitation and supervision. The courts often employed probation officers, social workers, psychologists to work with the children and family, as well to actually help with the juvenile court decision-making process. Most of the children during this time that were involved in juvenile courts were from poor families and many immigrant neighborhoods. The juvenile courts were different than any prior court that handled children's issues. Most juvenile courts handled minor offenses and status offenses. They were held in private, did not include jury trials, indictments, or other adult system formalities. They were, as I said, treating them more as civil and not criminal. The juvenile court took on the supervision of the child. The juvenile courts moved away from these initial reformative and informal supervision plans, and the state law began to define delinquency. We saw a significant expansion and commitment in the 1920s to the 1960s of many youthful offenders to juvenile court detention and incarceration. Facilities moved far away from the original parens patriae of the rehabilitative philosophy. Institutionalization became the primary determination and outcome for those involved with the juvenile courts. Most of these facilities were substandard, overcrowded, did not include any rehabilitative services or medical care, employed a controlling and punitive environment. While there were varying interventions that were tried within the institutions, therapy, group treatment, environmental management techniques, and others, the outcomes still remained poor. The juvenile courts continued to predominantly involve low-income and other people's children, though some alternatives to incarceration of youthful offenders were introduced as community-based corrections. 1960 to 1980, we saw more juvenile justice and individual rights. The court dockets expanded to include more minor offenses, truancy issues, child welfare concerns, along with criminal activity, saw a shift away from the institutionalized placement of youthful offenders to more community-based alternatives. Though the local city and county juvenile courts processed youthful offender cases, we saw referring juveniles to probation, supervision, and residential placement. Expanded due process for juveniles involved in the court system. The court expanded to involve, as I said a little while ago, the 60s and 70s saw a stronger federal government role, state reformation, and depopulating overcrowded incarceration facilities, and many, as I mentioned, U.S. Supreme Court decisions. The 60s addressed the increasing youthful offender crime by moving beyond just local and state efforts. The Kennedy administration during that time had recommendations from 61 Juvenile Delinquency Committee to preventive focus for those that were most at risk, identify delinquency being linked to the urban decay, poverty, school failure, and family instability, and establish diversion alternatives. First, establish the federal grant-making law, which is the Juvenile Justice and Delinquency Prevention Act of '74 that I've mentioned. There were funds programs for juvenile courts, separate youthful offenders from adults, remove status offenders from juvenile institutions, the removal of adolescents from adult criminal justice system unless charged and transferred to the adult court. Some states pursued shifting their large-scale and often poorly maintained correctional facilities towards more smaller community home-type environments. This movement was influenced by the broader deinstitutionalization of state psychiatric facilities by Kennedy that were driven by federal court decisions that focused on due process protections. The state efforts were led by Massachusetts, Missouri, Vermont, and Utah that decreased their youthful offender incarceration populations, in some cases by as much as 90%. However, this progress was difficult for many states to achieve, and most continued to just house large numbers of the youthful offenders throughout the 70s and 80s, as they had for decades earlier. The continued poor treatment of many juvenile justice involved offenders, particularly those that were in confinement, incarceration, and the perception that a social welfare approach was doing little to curb expanding juvenile crime resulted in increased focus on due process protection rights that we see within the Supreme Court cases. Critics at the time argued that the juvenile courts could no longer justify their broad disposition powers and invasion of personal rights on humanitarian grounds. Delinquent offenders were often treated like adult criminals, yet had none of the legal protections granted to adults. This is what led to the due process concerns that came to the Supreme Court in the Galt decisions. Also, during these 20 years, some states pursued shifting their large-scale and often poorly maintained correctional facilities towards a more smaller community home-type environments. And what we're going to see later in this class is this is what really works to help juveniles. The deinstitutionalization of state psychiatric facilities that were driven by federal court decisions that focused on due process protections. Also, the progress was difficult for many states to achieve, and most continued to house a large number throughout the 70s and 80s as they had for decades. The continued poor treatment of many juvenile justice involved youthful offenders resulted in an increased focus on their due process protection rights. Delinquent offenders were often treated like adult criminals, yet they did not have the legal protections that were granted to adults. The due process concerns came to the forefront of the juvenile justice system in the U.S. Supreme Court Galt's decision that I've just mentioned. The court found that youthful offenders facing delinquency, adjudication, and incarceration are entitled to certain procedural safeguards under the due process protection of the 14th Amendment. We saw a balance of the broad powers of the juvenile court by providing the legal protections to the youthful offenders that had had been for many years neglected of youth. The 1990s were really called the decade on the tough on crime area. The 80s and early 90s marked an aggressive shift towards public safety and accountability. There was an increase in juvenile detainment and incarceration, an increase in the transfer of youthful offenders to the adult criminal justice system. Between 92 and 97 is when we really saw the move toward get tough policies and passed laws accordingly. The reasons for moving from what was originally the rehabilitative to a more retributive, they saw juvenile crime as out of control, concerned with fictional new class of juveniles as super predators. That was really a myth. Belief juvenile courts that were soft on crime and ineffective, and the public and the legislatures, the intervention programs just didn't work. Beginning in 85, there was a growing crime problem in the youthful offender population across many states, though it was short-lived. There were arrests for robbery, forcible rape, aggravated assault, murder, and all of these increased dramatically. There was an increase most notable in the inner cities. The combination of an increase in handgun access, usage alongside an expanding drug trade was due primarily to crack cocaine epidemic in many of the nation's cities that fueled much of this increase in youthful offender crime. Many young people joined gangs. Many lived in fear of the increase in violent crime. There was a shift from the youthful offenders in need of intervention and support towards retribution and harsh accountability, apply severe punishments and sanctions, looked at deterrence and incarceration. As I said, we saw this super predator, which was a class of adolescents portrayed by the media as violent offenders who accounted for a minority of adolescent crimes. As I said, this is a myth to this super predator. 1994 saw the Violent Crime Control and Law Enforcement Act, where a number of consequences for youthful offenders were increased. We also saw the Gun-Free Schools Act. And today, our juvenile court reform, it's punitively focused. Our punitively focused juvenile justice system began to dismantle really towards the end of the 90s. The tough on crime responses by policymakers caused more harm than good. State budget strained by punitive policies. They moved to increase recognition that most youthful offenders are not serious or chronic. These juveniles do respond to preventive and diversionary interaction. There was a development of effective and evidence-based treatment. 2002 through 2012, there was a decrease in juvenile offenders, delinquency adjudication, commitments to juvenile court, and waived cases. The number of reformative trends that have occurred across state and local juvenile courts decreased. First, state could recognize the problems and complete reviews of their juvenile justice system effectiveness, focus on improving public safety, using effective prevention and treatment alternatives. There was a reformation of laws, returning or maintaining more adolescents within the juvenile court jurisdiction, transfer and waiver criteria laws. Trend is to raise the minimum age and keep youthful offenders in the juvenile justice system. Detention and incarceration reform and a focus on prevention, diversion, and evidence-based interventions. The foundation of the MacArthur Foundation, which is a Models for Change initiative, and the Annie E. Casey Foundation, which is a juvenile detention alternatives initiative. There was due process protection. States were now limiting the ability to waive counsel, improving quality attorney representation, and increasing attention to competency. The Juvenile Justice and Delinquency Prevention Act, as I said, moved forward on numerous priorities and reforms since the 1990s. There was initial shift states towards rehabilitative paradigm and identify what efforts are problematic at the state and local level. banned the use of solitary confinement for youthful offenders being held in adult federal prisons. Youthful offenders are different than adult offenders. This was actually being recognized. U.S. Supreme Court, sorry about that. The U.S. Supreme Court established the new paradigm on youthful offender sentencing, relying heavily on the development and brain evidence, science evidence. Some of this research identifies that adolescent brains do not fully develop until the mid-20s and finds this age group to be emotionally and impulsive. The juvenile court also saw reforms with the 8th Amendment that requires punishment to be proportioned to the offense. Some of the examples are Roper versus Simmons, Atkins versus Virginia, Graham versus Florida, Miller versus Alabama, Montgomery versus Louisiana. And prior to the Atkins v. Virginia, youth and adult offenders who were developmentally delayed could be sentenced by a jury to death row. Remember, that was a big case that those that are showed to be developmentally delayed could no longer be sentenced to death. The juvenile death penalty was abolished in 2005, and also a life sentence without the possibility of parole was abolished. Graham versus Florida was the life term, abolished the life term for non-homicidal youthful offenders. Miller versus Alabama found the mandatory life without parole state laws were found to be unconstitutional, and Montgomery v. Louisiana retroactively applies the Miller decision to all youthful offenders, so it allowed for the resentencing hearings and immediate parole eligibility for those that had already been sentenced to life without parole.